We're now joined by the African Transformation Movement's Vuyo Zungula, who has vehemently opposed the committee continuing their work without Busisiwe Mkhwebane's legal representatives. Thank you very much, sir, for your time this afternoon. Perhaps you can help us in terms of a learning moment here. What do the rules of Parliament prescribe in such a case?
Firstly, where we are, we're in inquiry to determine the fitness of Advocate Mkhwebane. Now, there's a court judgment that stipulates that in the inquiry, the public protector must have legal representation. And they quoted even how judges, whenever their fitness is heard by the JSC, they are also represented by legal representation. Now, what happened yesterday is that the public protector could not continue because as things stand now, she's still on the stand and giving testimony. She could not continue because of the absence of the legal representation, because the Office of the Public Protector on the 1st of March already said they are unable to fund the legal representation of the Public Protector after March. So that is where we were yesterday. Now, after hearing that situation, the chairperson then said, all right, we cannot proceed with the Public Protector. However, we are going to request the evidence leaders to empower the committee. Firstly, the committee has never said we wanted the evidence leaders to empower us. The second issue here is that the members, the evidence leaders are not members of the committee, because the chairperson keeps on saying the meeting now is a committee meeting only dealing with issues that are raised in the committee and only members of the committee can participate. However, it is the evidence leaders that are continuing to give evidence because they're dealing with evidence that was presented by the public protector in the past weeks. The issue of the Reserve Bank, the issue of the SAR-17 bank statements. So in our view as the ATM is that the committee must not sit up until the legal representation is done, because we do not want a situation whereby the committee works, a lot of money is spent, a lot of time is spent only for the report to be overturned by a court of law because there are parts of the process that did not include the legal representation of the PP, whereas there's a court judgment that affirms that in the entire process of the inquiry, the PP must be afforded an opportunity to be represented by legal representatives.
Essentially, are we hearing that the chairperson of the committee is acting outside of the rules of Parliament and in contempt of court?
Definitely, because there's a court order, to that effect. And also what's very strange to what happened yesterday is that immediately after it was decided the public protector cannot continue giving testimony, the chairperson invites the evidence leaders to empower the committee on certain aspects, and they continue to attempt to empower the committee. The question would be, when did they know that there will be such a request from the chairperson? When did they get to prepare? Because in a meeting, the agenda for yesterday and today and for the coming days has always been hearing the testimony of the public protector. There is no other agenda that was discussed and agreed to by the committee. Therefore, now to mid-meeting, you change the agenda, and the people that you are saying must present, they are so ready, meaning there was a decision that was taken somewhere that this is what is going to happen. And what is currently happening now, the evidence leaders are somewhat giving assistance or empowering the committee. But what in fact they are doing, they are somewhat trying to do damage control or influence the members of the committee based on the testimony that was given by the public protector last week. And that is against the directives of the committee, the rules of Parliament, and the Constitutional Court order to that effect.
Now, what options are available to then interdict, for lack of a better word, this process from going on? Because the person who is supposed to be giving the testimony is not available, and her legal representation is not available. Well, she is available, but yeah, her legal representatives aren't.
If Parliament, particularly that committee, was pursuing justice in the matter of the fitness of Advocate Mkhwebane, the first thing that they would have done would have been to say there is no legal representatives of the public protector, and we cannot continue with the inquiry because that will be in violation of a court order. But they don't do that, which clearly shows that this committee that we are part of, that inquiry has got, it is not a fair inquiry whereby the outcome is unknown and it's just a matter of looking at the evidence that is before. It is the witch hunt that is clearly being exposed time and time again, that their intention it is to remove Advocate Mkhwebane. And it is not really about Advocate Mkhwebane as a person, but it is about any public representative or official that will do their job diligently and within the law and find against the powerful, which is the likes of Mr. Ramaphosa. So that is what they are doing. So that is why as the ATM, we want to have a fair and just process so that we have a country whereby justice is the order of the day, not a case whereby Parliament will be used to suppress and subjugate the rights of other South Africans for simply standing for the truth or simply doing their job in the manner in which the Constitution requires.
In fact, it's not just the ATM. An ANC member yesterday also advised against the process going on without Mkhwebane's legal representatives. The EFF, the Good Party, the UDM also opposed to the process going on. What do you make of the attitude of the chairperson? You suspect that decisions were made somewhere. To what end?
It is very clear. I think for him personally, he's campaigning to be a minister or to be a permanent committee chairperson. So I think that is what he's doing personally. But in the context of the committee, he's driving the committee to one outcome, which is that Advocate Mkhwebane must be found that she is not fit, to be public protector. Now, that is why they are trying to find means and ways to even ignore court orders, to even ignore the rules of Parliament, even ignore the directives of the very same committee. That is why, for example, a simple thing like you just stated now, many members from different parties are saying, let us postpone up until he, as a chairperson, engages the Speaker. And after engaging the Speaker communicates to Treasury on behalf of Parliament to say, Treasury, please advance some resources to the Office of the Public Protector because there's a process we cannot complete because there's a lack of funding. Now, that is the rational thing to do, but he does not want that to be done because the continued presence of the legal representation of Advocate Mkhwebane means they will object to whatever that is wrong that will be said by the evidence leaders. Now, in the absence of the legal representation, the evidence leaders can do whatever they want to do without any objection and without anyone calling them out that they are doing something wrong in terms of the law and the directives of the committee.
ATM President, African Transformation Movement, Vuyo Zungula, thank you very much, sir, for your time this afternoon.